In 1984, Dr. Karen Reisig, an OB GYN in Oklahoma, performed a medically indicated hysterectomy on Edith Smith. During surgery, the bladder was injured. It was recognized, it was repaired. No further complications. Mrs. Smith later sued her physician, not because her bladder was injured, not because the risk was undisclosed. She sued because of something that never happened during the informed consent conversation. Something most of us would never expect to cost a lawsuit, and yet, it did. The case went all the way to the Oklahoma Supreme Court, and the physician lost. In this video, I'm going to show you why Dr. Reisig lost this case over one essential component of informed consent, and that single omission was enough for liability. We will use this case to examine how similar gaps show up in everyday practice, how we unintentionally narrow options before a patient ever chooses, how we mistake information delivery for real understanding, and how time pressure can compromise autonomy. These are not abstract ideas. These are principles outlined by ACOG in Committee Opinion 819 on informed consent and shared decision-making. Because once you see what she missed, you may start questioning your own consent conversations. Here's what actually cost her the case. Mrs. Smith came in with abnormal uterine bleeding, and Dr. Reisig recommended a hysterectomy. During the visit, the procedure was explained. The risks were reviewed. Consents were signed. During surgery, the bladder was inadvertently entered. It was recognized. It was repaired. The patient recovered. Clinically, the case was over. Legally, it was just beginning. Dr. Reisig's defense argued that surgery was appropriate and that the risk of bladder injury had been discussed and documented. Mrs. Smith actually agreed with all of that, but she testified that hormonal therapy was never discussed. The consent form on file included the word alternatives, but no mention of what those alternatives were. The case did not turn on whether surgery was reasonable. It turned on whether hormonal therapy had ever been presented as a genuine option. Not whether it was better, not whether it would have worked, not whether she ultimately would have chosen it, but whether it was part of the decision at all. And the evidence showed that it was not. ACOG is explicit. Informed consent requires discussion of all treatment alternatives and documentation that reflects that conversation. Once hormonal therapy was missing from the conversation, the decision was no longer fully informed. Narrowing the options is what cost her the case. But there is a second mistake we all make when obtaining informed consent. ACOG is very clear. In seeking a patient's informed consent, physicians should assess the patient's ability to understand relevant medical information and the implications of treatment alternatives. Assessment means we do not assume understanding. We have to confirm. What we usually do on a daily basis is to ask the patient, "Do you have any questions?" If the patient says no, we assume the patient understands. But according to ACOG, that approach is substandard. We have to be intentional and have a process to assess understanding. This proven technique that can help you achieve that goal. Chunk and check. Let's say you have a patient at 20 weeks whose anatomy scan report an echogenic intracardiac focus. Most of us would read the finding, review the statistics, and then present further testing options. That is a lot of information delivered all at once. The patient might be able to make a decision, but that doesn't mean that she fully understands all the options. Chunk and check is different. You divide the conversation into short, deliberate segments. First, you explain the finding briefly and clearly. Then pause and ask, "Before we talk about next steps, can you tell me what you're understanding so far?" Only after that do you introduce the options. Then pause again. In your own words, can you tell me what the options are? You are not testing your patient. You are assessing understanding in real time, layer by layer. Because consent is not about how clearly we spoke. It is about whether the patient can explain the choice she is making. And even when we name options and confirm understanding, there is still one more situation where consent can break down: when time pressure compromises autonomy. ACOG states that it is commonplace for clinical decisions to be made quickly during labor and delivery. That is our environment. Fetal heart rate changes, acute bleeding, severe hypertension. These situations narrow our focus and we shift into action mode. Our language becomes more directive. We need to move. We don't have much time. We are not trying to override autonomy. We are trying to prevent harm. But here is the problem. Not every concerning tracing means the same thing to every physician. One physician may see an emergency. Another may see just a pattern that is evolving. One may move to cesarean immediately. Another may observe a bit longer. When the situation feels emergent to us, our tone changes, and the choice can start to feel less like a choice. Under these circumstances, we may emphasize risks more heavily, even if those outcomes are uncommon. But this compromises autonomy. In labor and delivery litigation, a common allegation is patients claiming that decisions were made under pressure without adequate discussion. In many of these cases, courts have determined that the situation was not truly life-threatening and did not justify bypassing a full informed consent process. So, how do we minimize this risk? We probably can't change our own threshold for action. That's just the way we practice. But there's one thing we all can do to decrease the chances of substandard informed consent under time pressure: anticipation. ACOG recommends, whenever feasible, it is particularly important to initiate anticipatory conversations about delivery possibilities. The best way to protect autonomy under pressure is to start before the pressure shows up. And this is where we often fall short. A tracing becomes concerning. We walk in, we reposition, we give fluids, the heart rate improves, and we say, "Baby looks fine now." But how often do we take the time to frame the situation clearly? How often do we say, "Here is what could happen. Here is how we would think about it. Here is when we would change direction"? Time pressure can compromise autonomy. Anticipation makes the decision feel like a continuation rather than a sudden turn. And just to be clear, urgency does not lower the standard. ACOG is explicit. Regardless of anticipatory conversations, physicians are expected to initiate as full an informed consent process as possible in time-limited scenarios. Even under stress, the patient still has the right to hear the options, to ask questions, to refuse. Time pressure is not an excuse for inadequate informed consent. What happened to Dr. Reisig in 1984 could happen to any of us. Time after time, these cases come down to a single question: what was actually discussed at the time of informed consent? And as we saw in this video, the consent process is well defined, which means when something is missing, you can be certain it will be pointed out during trial. This is not about defensive medicine. It is about disciplined, patient-centered care. Informed consent is not a form. It is not a signature. It is a structured process. You have to assess the patient's ability to understand. Always include diagnosis, interventions, and alternatives. Do not forget to document the conversation as opposed to just signing a generic piece of paper. Dr. Reisig's case was not about a complication, it was about a missing step. And in our specialty, missing steps compromise patient care and make us vulnerable for litigation. Subscribe to Pathways OBGYN for evidence-based practice and smarter clinical decisions.